Hey everybody, this is Shawn Adams coming at you again with another legal clinic. And today we're going to be talking about the Residential Tenancy Branch. This one is unfortunately not live because we had some issues with respect to the live stream. But we're going to make this one as informative as possible, as helpful as possible. We're going to have maybe a little bit of fun as well. You'll see what I have planned. But this particular one, we're going to talk about the Residential Tenancy Act and the Residential Tenancy Branch in general. Now, if you're looking for advice about evictions, we're going to have an entire separate video. That's going to be a part 2 video because I looked at the Residential Tenancy Act and I realized just how much there is to cover and just how many questions people have about how it works. And I mean, granted, it's a huge act. It's very long, and without an understanding in the law, it can be a little bit difficult to understand. So let's go through all of that together so that I can help you make this as simple as possible for you. This will apply to you whether you're a landlord or a tenant. Either way, this is all helpful information. So, if you're doing this for the very first time as a landlord, a tenancy starts with a tenancy agreement. The tenancy agreement is a contract, and it's stating what the landlord's offering and also what the tenant is expecting when a property is rented out or a property is leased. Now, this isn't about ownership of property. This is very important. This is not about selling property or doing mortgages or realty or anything like that. That's all covered in civil court. So if you're looking for advice about that as a landlord, talk to your lawyer. They can probably give you some advice about selling a property and things of that nature. So residential property rentals, like I said, are covered by the Residential Tenancy Act, which is the statute where all of the laws are found, and there is also some regulations under the Residential Tenancy Act that you also have to follow. And then there's the Residential Tenancy Branch. This is a tribunal that's administered by the BC justice system. It's separate and apart from a court. It's not a court. It's actually a dispute resolution mechanism in the hopes that you don't have to go to court about evictions. It does have what's called exclusive jurisdiction over all residential tenancy matters, which means that when there is an issue with evictions, with property maintenance, with who's coming in and out of a unit, with perhaps a unit that's being demolished or changed into another type of zoning, something like that. All of those types of cases are heard at the RTB. So just keep that in mind. Appeals from those go to the BC Divisional Court, which is where administrative law appeals are heard in BC. It is also the same in Ontario. There is a divisional court in Ontario. They cover administrative law as well. All tenancy agreements have to be in writing. And the reason it must be in writing is because it affects the tenant's living situation. It affects their well-being. If something goes wrong with that tenancy agreement, that tenant is homeless. And the landlord doesn't get the rent. So it's in the interests of everyone involved that a tenancy agreement runs smoothly. And a lot of people will say, oh, well, the landlords are just out to get people, or, oh, the tenants are just out to get people. I don't believe either of that. I think that both the landlords and the tenants are looking for something good out of the tenancy agreement, and it falls apart because of the situation a lot of the times. I don't think that any one of them are particularly to blame, one more than the other. All of this, oh, the tenants always cause damage, oh, the landlords always take security deposit. It's simply not true, at least in BC. That's not been my experience at all. There are always at least two parties to a tenancy agreement. The tenant is the person who rents the property and pays the rent and has the guests over and makes the messes that the tenant has to clean up. And the landlord is the person who receives rent from the tenant and all of their roommates as well. It's also the person that makes decisions, sublet or assigned. We'll get to that in a minute. So the tenant is the person that's listed on the tenancy agreement. This person might have roommates. They might have people coming in and out of the house to visit the house. But the person on the tenancy agreement is the person who's the most responsible. They're the person who if everything doesn't go according to plan, that's the person the landlord pursues for rent. That's the person that the landlord speaks with first before anybody else, is the person on the tenancy agreement. So if you are looking to sign a tenancy agreement and to move out on your own with roommates, have a conversation about who is going to be on the tenancy agreement. Who is a tenant, who's a roommate, when is rent due, who is rent paid to, and who distributes the rent to the landlord. Critical questions. You must answer these questions even before you start writing your tenancy agreement. Who pays the rent, who's responsible for what, and I would also have some agreements about cleanup. Who's responsible for cleaning? Who's responsible, when there's a leaky, if there's a leak anywhere in the unit the person is renting out, who's responsible for fixing the leak? Good question. Well, the landlord's the most responsible, but the tenant also has a responsibility to fix those types of maintenance problems. There may be more than one tenant or more than one landlord, and so it's critical in your case to look at who's named in the tenancy agreement. Are you the landlord, are you the tenant, and who's listed there? So in determining, sometimes landlords are uncertain about whether a person's a tenant or not, and they might have to make an argument before the residential tenancy branch that somebody is a tenant even though they haven't signed the tenancy agreement or something like that. So in determining whether somebody is or is not a tenant, the RTB is going to look at a couple of different factors. First off, how long have they stayed there? Have they been there for a majority of the tenancy agreement? Have they been there just a short period of time? Did they visit and then leave? What was the arrangement? How long? Do they have a controlling interest in the property? Do they have keys? Do they have a key fob? Can they access the building? Did they pay for a security deposit for a second set of keys or a third or a fourth? Then you might be looking at people who were tenants. Do they pay rent? Critical question. If they're paying rent, most of the time, they're a tenant. Simple enough. Do they have a room or a space that's just for them? If they're coming in and sleeping on the couch, it's unlikely that they're a tenant. But if they have a space in the unit that's dedicated to them, it's more than likely they're a tenant. Have they had any interactions with the landlord or the tenancy agreement? And if so, how many interactions? If they've spoken with the landlord a bunch of times to make agreements or has had to negotiate repeatedly with the landlord to stay there as long as they have, chances are they're a tenant. On the other hand, if they have never met the landlord, they're not on the tenancy agreement, they have no idea what the tenancy agreement says, chances are they're not a tenant. Do they list the property on utility bills, ID cards, internet, registration, or on personal documents? If they're listing the address on all of their documents, chances are they're a tenant. If they're not listing and they're listing a different address, chances are it's a temporary situation and they'll be out soon. They're not a tenant yet. Have neighbors witnessed this person occupying the unit? The landlord might be able to say, we've seen a whole bunch of people, we've seen witness statements from them stating that that person has been in and out of the complex or the unit or the building again and again and again. And so at that point, then you have witness statements that you can use in the residential tenancy branch to prove that yes, that person was a tenant and that they're responsible for whatever the tenancy agreement says or the Residential Tenancy Act, as the case may be. And it's important also that if a person is not a tenant, it could be that the tenancy agreement does not apply to them. So keep that in mind as well moving forward. There are two types of tenancy agreements. There is a fixed tenancy agreement and a month-to-month or unfixed tenancy agreement. So a fixed tenancy agreement means that the tenancy dates are fixed. There's a start date of the tenancy, there's an end date of the tenancy, and so you know exactly when the tenant is coming in, when they're going to be occupying the unit, and when they're going to be leaving. Fixed tenancy agreements are preferable in Canada. And that's because you know how long they're going to be there, you know what to expect, you can prepare properly for that. Usually they're for 6 months to a year. Occasionally, landlords have been known to do more than 1 year, especially gated communities or communities where you would want somebody there for a long period of time. The tenancy ends when the end date is reached, and then the tenant has to move out by 1 p.m. of the date of the tenancy ending. That's 1 o'clock p.m. Not noon, not 11:59 p.m., not 9 a.m. It's 1 o'clock p.m. Unless the landlord and the tenant consent to a different arrangement, and then that's fine. So then there's the second type of tenancy agreement, a monthly or unfixed term. Means that there is a start date, but there's no end date. And how you end up with a month-to-month tenancy is if a tenant and a landlord have expired a fixed tenancy, usually this is how it happens, and the landlord decides to continue that on a month-to-month basis, so then they have the flexibility of deciding when the tenant is going to stay and leave. The best thing to do when you have a fixed term tenancy is to renegotiate your tenancy again. Shouldn't have to do this year after year, but if you enjoy your place, you can contract for a longer term of a tenancy, and especially if you have a good relationship with your landlord. So what is in an actual tenancy agreement? What are the different things that need to be mandatory in a tenancy agreement for it to be lawful and legal? So the full contract details, including the postal codes of landlord, tenant, and the person who owns the building, if that person's not the landlord, must be on the agreement. The start and end date of the tenancy must be on the agreement. Whether the tenancy is a fixed term or month-to-month also needs to be notified, but I suppose that's kind of notified with the start and date of the tenancy. And then, of course, it sets out even more detail. You can find, if you're a landlord, you can find templates for a tenancy agreement online at the Residential Tenancy Branch website and download those if you do not have a tenancy agreement. Most landlords, especially corporate landlords, will have some sort of pro forma, meaning pre-existing form that they can use with respect to tenancy agreements. So they have all the clauses laid out already. Read your tenancy agreement when you get it, and also when you are ending your tenancy, so that you understand the terms of what you have agreed to and signed. And always make sure you agree and that you understand what is in the tenancy agreement. And if you don't agree and you don't understand, it's vital that you at least communicate with the person, if not get an attorney to look at the tenancy agreement and to dispute it. Some things at the start of tenancy to be aware of. So the landlord may not charge any tenant an application fee at any time, for simply applying to occupy the unit, and at the landlord's expense. And if this is charged to the tenant can claim that money back. We'll get to that in a minute. Section 14 sub 1 of the Residential Tenancy Act says landlords and tenants cannot contract out of standard tenancy terms, and those terms are listed in a schedule at the very end of the Residential Tenancy Act. For example, the landlord and tenant can't agree just out of hand that, there's going to be no running water and no electricity at your rental unit, and with no reduction in rent. That's not something that you can contract out of. It is a standard term that in BC you must have life essential services available in the unit, like water, like electricity, like your ability to have a shower, unless they've given you 30 days notice. At the start of the tenancy, the landlord can charge 1 security deposit and 1 pet damage deposit. And both of these are 2 different deposits. They can be up to 1/2 of 1 month's rent. And then the security deposit can be up to 1/2 of 1 month's rent. So they can ask fully for 1 month rent in advance as a deposit. That is what they are permitted to do under the law. And the deposits must be used for that purpose as a deposit. You can't spend that money because you have to give that money back to the tenant at the end of the tenancy. And if the landlord overcharges the tenant on a deposit, the tenant can get that money back too. And this is vital as well. The deposits do not count as rent. Rent has to be paid in the last month of the tenancy still. So in a lot of provinces, you pay first and last, and then when you leave your unit, hey there, Ribby, our paralegal's here. Again, she always comes by when there's a legal clinic. She knows when they're happening. You still have to pay the last month in BC. A condition inspection takes place when the tenant takes control of the property. This also happens at the end of the tenancy when the tenant leaves the property. These two inspections are mandatory for the landlord and the tenant because they need to be able to examine the state of the unit and to determine whether any repairs need to be done, whether there's some cleaning that needs to be done, and it needs to be in a good state of repair for the next tenant, the next person that's moving in. Because if it's not, the landlord cannot rent that unit out to anybody else until those issues are taken care of. A copy of the inspection has to be provided to the tenant. The landlord keeps a copy for their own records. If the inspection is not completed by the landlord can't claim against any of the deposits. So this is why it's essential. You have to do your inspection. If not, all of those damaged deposits, you can't keep them. Because how do you know the state of the unit if you've never inspected it, or if you've inspected it insufficiently, or if you've not given the tenant enough notice to show up? How can you say that it's damaged when you haven't even looked at it? If the tenant does not attend, the tenant is not entitled to their deposits. So it's equally important. The landlord needs to show up and the tenant needs to show up. The landlord and tenant can have up to 2 different opportunities to do that inspection report before statutorily and legally speaking, they're in trouble. They're in hot water and they missed it. So they need to have at least 2 opportunities to do that inspection. And if they haven't met their obligations, like I said, they're out on whatever deposit they are supposed to be returned or that's supposed to be kept. It's good practice also for landlords to relock the key lock for the unit that they are renting at the start of the tenancy. And also, especially if the tenant requests this, it must be done. But it's good practice in general for landlords to get into the rhythm of when a tenant moves out to fix up the unit, clean it, to rekey the lock, and then to have a new tenant come in as soon as possible. Landlords ought to make sure that the property is empty before rekeying the door, so all of the personal affects of the tenant need to be out of the previous tenant, that is, need to be out of the unit, and the unit effectively has to be abandoned and vacated before they can start making those changes. So let's talk about, I'm so itchy today. Let's talk about the conduct during the tenancy. So how does the tenant need to behave when they're occupying a landlord's unit? So tenants need to pay the landlord on time. Pretty simple, pretty straightforward. Unless they have a right to withhold rent under the Residential Tenancy Act. And if that's the case, they need to send written notice as to why they're withholding rent. So landlords must issue a receipt when rent is paid in cash. Typically, they'll offer some sort of receipt to begin with. The landlord shall not interfere with the personal property of the tenant, irrespective of whether the tenant's paid rent or not. That is their belongings. The landlord is not entitled at all to any of the personal property, personal affects of the tenant. No matter how close they are, they could be best of friends, they could be brother and sister, it doesn't matter. You can't touch the tenant's personal property, even if they're in rent and arrears. You can't walk into their, and this court case has come up quite a few times, where a landlord walks right into a unit, grabs a tenant's belongings, and sells them to satisfy the past rent. You cannot do that, landlords. You cannot do that. It is illegal. It is illegal, and you will be fined if you do it. Simple enough. Couldn't make it any more simple. If you're a landlord, do not do that. If a landlord must terminate a non-essential service like parking, gyms, a library, like a common area, maybe there's it's like a dormitory style, so there's a sitting area, maybe on the roof. The landlord must give 30 days notice to all residents, and they also must reduce the rent accordingly. Now, if it's closed because of an emergency, that's another story. They have to place a notice containing the number of the person that they need, that the tenants can call for that emergency. The landlord shall not terminate any service that is essential to the tenant living there without significant notice. For example, internet, laundry, kitchen, bathroom, shower, water, electricity. These are essential life-providing services. You cannot get rid of them. Landlords, you cannot get rid of those either. And if you get rid of them, there are consequences. So what does the tenant have the right to when they're occupying a unit? So the tenant, under the Residential Tenancy Act, a tenant has the right to reasonable privacy. It's their space. Their space can't be intruded on. You can't record them. You can't go walking around their property, looking through their windows, trying to see what they're doing. They're entitled. If they want to have their blinds closed all day long and put curtains on top of them so that you can't see them, they're entitled to do that because they're entitled to reasonable privacy. Reasonable enjoyment, freedom from unreasonable interference or disturbance. This means that other residents can't just come up to you and play Nicky Nicky Nine Doors every other day and expect that nothing's going to happen. This is your unit. This is money that you pay so that you have a private space, a safe space, if you will, where you can just chill out, where you can relax, where you can be, free from unreasonable interference. Because a lot of people interfere with you during your workday and when you go outside. Have you noticed that? People are asking you to wear masks and keep your 6 feet and shouting at you apparently because you're agreeing and going along with, or you're not going along with. So people are just going to shout at you anyway. And your rental unit is your one place where you should be free from those people shouting at you, banging at you, harassing you, disturbing you with the ridiculous nonsense. That also includes loud music, loud noise, pets barking all the time, pets pooping and making a stink, and people not cleaning it up. Those sorts of things cause a disturbance. And you can't do that. Exclusive possession of the unit, subject only to the RTA's clause about necessary landlord entry. This unit belongs to the tenant, not to the landlord, not to the landlord's friends or guests or roommates or buddies. The unit does not belong also to the tenant's buddies. It belongs to the tenant. That means that the tenant has exclusive possession. If they want to kick out a roommate who is not paid rent, they can evict them. They can do so because they have possession of that unit. If they want to decide that some ugly statue that the landlord put in their rental unit doesn't really belong there, it should be outside, well, then they can do that because they have exclusive possession of the unit and the items inside of the unit. Tenants cannot grow marijuana plants in residential properties. I know, ridiculous. It's BC. Should be allowed to grow marijuana if we want, but that's the law. You can't grow plants, marijuana in rental properties unless, and this is the exception, unless it's medical marijuana that's grown with a license and for medical purposes, and then you can grow all of the medical marijuana that you like. You cannot smoke or smoke cigarettes. You cannot smoke cigarettes or marijuana in most rental units. Just not allowed. And the reason's because if you have white walls or white floors or white blinds, it discolors them, creates all kinds of problems. If you're smoking cigarettes, you're leaving carcinogens that sit and stagnate in the air, that stagnate on anything that retains liquid in any way. It stains it. It's disgusting. I've actually had this problem with my own property, with a former house that I used to own. We had to come in and scrub all of the walls and scrub the whole floor and scrub all any surfaces that were contaminated. And if we had have done that with a commercial agency, it would have cost us $500 to bring somebody in with all this specialized equipment. I'm not sure exactly what they have to clean up all of this cigarette smoke and all this marijuana smoke. So if you are going to smoke, please vape, because vapes at least don't cause that level of damage to the walls, to the blinds, to the floor. Cannabis is vaporized. The RTA does not recognize this as smoking cannabis. So vape away, but don't smoke in your unit. Landlord entry. Landlords must give notice 3 days before entering a rental unit, including the time, day, and reason for entry. They, with consent, can enter a unit 30 days before an expected entry, as long as the tenant says that's okay. Landlords can provide for monthly inspections based on the tenancy agreement. If that's something that's in the tenancy agreement, you're kind of cooked. You've already signed on it. So they get to inspect every month. Landlords may enter to perform homemaking services as agreed to under the tenancy agreement. So perhaps this is a long-term care home, and under those circumstances, there may be an agreement under the tenancy agreement that those individuals are allowed to come into the property, clean the property, maybe talk with the tenant, make sure that they're okay, that they don't need anything medically speaking. And so that's permissible as well. The landlord may enter for those services, and those services alone. Landlords may enter an abandoned rental unit without notice. If it's being abandoned, and it's being abandoned for, I believe, 60 days, the landlord can enter to check out the property to make sure it really is abandoned. Landlords may enter to protect life or property under the circumstances of an emergency. When I say emergency, this means a 5-alarm blaze. This means somebody is actively dying or being harmed. This is not something like, I forgot my iPod in there and I need it right now. This is a serious emergency for which someone would call 911 and give a very screaming type of attestation to the person who's on the line. Like, that's an emergency. If you, the tenant really, I mean, like I said, they have an expectation of privacy. They have an expectation of nobody being allowed to unreasonably disturb or interfere with them. So if the landlord needs to enter a property, it has to be under exceptional circumstances. The tenant has a right. The tenant has a right to privacy. The tenant has a right to be free from unreasonable, search and seizure of their property by the landlord. That's actually the Charter of Rights and Freedoms, but that only applies to the government. Tenant and guest entry. The tenant can have anybody they'd like on the rental property effectively, as long as they are breaking the law or busting up the property. It really shouldn't matter that much to the landlord who's coming in and out. If they're concerned about something illegal, they should make a police report. Landlords shall not unreasonably restrict access to the rental property by the tenant or their guests. They cannot lock out the tenant out of the unit. They cannot lock guests out of the unit. They cannot create some system where guests have to sign in. Not appropriate. They cannot unreasonably restrict access unless there's been like a shooting in the area or something super serious, super serial, where they need to know who's coming in the property. Then maybe it's acceptable, but your mileage may vary. Contact your lawyer, paralegal, or resolve it if you think that's the case. Obligation to repair. So the landlord needs to follow health, safety, and housing standards. And not only do they have this high standard of care, but they also need to have regard to the age, the character, and the location of the rental unit. So if this is a 50-year-old unit, there's less of an expectation. But if the unit is 100 years old and there's substantial needs for repair and there's been asbestos scares in the past and et cetera, maybe it's been a meth lab in the past, they need to take that much extra care over the property, having regard to that circumstance. If a landlord breaches safety standards, health standards, housing standards, It does not matter when the tenant became aware of this. It does not matter. They can still bring a claim. They can still bring a claim. Ignorance of the law in Canadian law is no excuse. Might be an excuse in America, might even be an excuse in the UK. I don't think it is. But it ain't an excuse in Canada. Tenants must maintain reasonable health, safety, and sanitation standards in the unit. Pretty straightforward. We all know what a messy unit looks like. We all know what a clean unit looks like. And in terms of quantifying what this looks like, it would be, I think, the minimally accepted amount of cleanliness. So, if a tenant has a whole bunch of clothes strewn and they don't have a chance to clean up this and that, it should be acceptable to the landlord. But if there's dirt that's causing insects to show up, if there's, wildly inappropriate hygiene standards that's going to get somebody sick, if they're perhaps hoarding on the property, then that goes way past the typical, like, this is unclean, didn't get a chance to clean it. And in that case, the landlord could bring a claim. Tenants must repair damages caused by themselves and their guests, even if by neglect. If it's an accident, they still have to repair it. For example, let's say you're moving furniture and you accidentally cause a hole in the wall. This legitimately happened to me. I was moving a really big couch, and you needed two people to move this thing. And as I was moving it through the door, I don't know if it was me or the other person, but somebody slipped and it went sideways, and the lower right-hand peg slammed right into the wall. And I'm like staring at this hole in the wall that's the size of my fist. It looks like I put my fist through the wall, and I didn't. It was the couch. But if something like that happens, and we all know that's an accident. I didn't force the couch into the wall. That's an accident. If that happens, the tenant is responsible for just getting some plaster or putty and just fixing it. They don't have to paint it. They don't have to make it look all fancy. They don't have to, stain wood that's been broken and fix it and do all this fancy carpentry work. You don't have to do that. Just fix it so that it looks reasonable. Because when the landlord comes in at the end of the tenancy, they're going to fix everything anyways. They're going to paint it all over. They're going to re-putty all of the wall and the ceiling and etc., etc. As long as you made an effort as the tenant to do a maintenance repair, especially if it's negligence, you're fine. You're fine. And if they come after you and take your deposit when you've made an effort to fix it, dispute that, because that's... Your mileage may vary. Check your lawyer, paralegal, resolve it. And the tenant is not required to repair regular wear and tear. Not required. Let's say that there's gravel outside, and the gravel looks really discolored now and all dirty because there's been people walking on the fresh gravel, and now the gravel looks all worn, and the landlord's upset about this and they want to sue. They can't sue. Because it's regular wear and tear. It's people walking on it, and it would look like that whether people were walking on it a lot or walking on it a little bit. It's regular wear and tear. When you buy fresh pants, the smell of the fresh pants goes away. That you can't sue the store because the smell of fresh pants isn't in the air anymore. It's regular wear and tear. You know what I mean, right? Emergency repairs. So, the landlord can take over emergency repairs at any time, according to Section 33 Sub 4 of the Residential Tenancy Act. And they can do this as long as they provide notice to the tenant that an emergency is taking place. So that's the first thing you should do as a landlord. If there's an emergency like a big leak or a sewage fallout or, something that gets rid of something that's essential, especially like the shower goes out, or something that you need, the refrigerator or the oven, something that's an emergency. And you need to notify the tenant immediately, as soon as you can, that an emergency is taking place and that you're making efforts to fix it. And that when they get home, they're going to have to deal with it. It's a hard conversation, difficult one, but it's one you have to have. So the landlord must post a conspicuous notice or provide directly to the tenant the name and number of a person to contact in case emergency repairs are needed. It's up in the air, and it depends on your tenancy agreement about who is paying for the maintenance. Sometimes you will need to pay the maintenance. Sometimes the landlord will send somebody. But at any rate, if you, the tenant, are the one paying for those emergency repairs, you can reimburse yourself for the cost of those emergency repairs by invoicing the landlord. And if the landlord does not reimburse those emergency repairs and you have served notice to them, then Section 33 sub 7 of the Residential Tenancy Act allows the tenant to withhold rent. Now, I would heavily advise, because I am not giving legal advice on this legal clinic, I'm only giving general advice about the law and how it applies in BC to this one particular tribunal. So, if this is the case and you're thinking about withholding rent, do not do it right away, because you need to make sure that what you're doing is lawful. So, contact, and I would actually advise to call the Residential Tenancy Branch themselves and ask if it's a circumstance where you can withhold rent. And then there's a record of you having contacted the Residential Tenancy Branch. So please don't withhold your rent without first giving notice to the landlord as to why the rent's being withheld. And also, if you're inexperienced with the law, and especially with renting, call the Residential Tenancy Branch and make sure that you can withhold rent. Assignments and subletting. This is pretty straightforward. This is where you have a unit and you can't be there anymore, so you want to assign it to somebody else. That's called a sublet. You can also reassign a tenancy agreement. So one person, maybe they bought themselves a house and they don't need to rent anymore, but they want to give that unit to somebody else in their family who needs it. So then they would change the name from the one person to another person. So tenants are generally permitted to assign and sublet. This is done with consent from the landlord. The landlord will usually provide consent. If they allow this, they're not losing out on rent, because if they don't allow it, then the unit's going to be abandoned or vacated, and then they can't collect any rent. So that doesn't help them much. The tenancy agreement needs to have 6 months or more remaining, and it also needs to be a fixed tenancy. Those are the stipulations for assignment and subletting, that there has to be a significant amount of time left. It has to be usually pretty much near the start or middle of the tenancy. If it's towards the end, you're not going to get a sublet or an assignment, because it's just too late. It's too late to find somebody new. The landlord must have excellent reasons for not giving their consent to sublet, and that's included in the Residential Tenancy Act. So I got a question from a landlord asking how much money they're allowed to raise the rent by every year, when that can happen, etc., etc. They asked that their question be confidential, and so I will respect their privacy, and I will not reveal their name or address or location. But they did ask about that, and I want to acknowledge that person, and I want to give them an answer to their question, because it's a very legitimate question. So once a year is when you can request a rent increase. Usually this is done during the tax season, when there's a reevaluation of finances to begin with. So the rent increase is whatever the inflation number is from the Bank of Canada, so long as it's a tenancy agreement that they started 2019 or later. If it's earlier, there's a different equation. Check with your lawyer, paralegal, or resolve it, and we'll tell you what that equation is. But right now, as of 2019, the rent increase is the inflation number. And I did a check for you, in landlord individual, and presently the inflation rate is 8.1%, meaning that the percentage increase of the rent every year can be 8.1%. So let's give an example. If the rent was $1,000 in 2021 and you're increasing it for 2022, you can increase the rent by 8.1% for the tax year 2022, starting in April, if you're doing it by the books, which makes the total rent $1,080 or $1,080 in 2022. There you go. There's your math. I hope that helped. The landlord needs to give 3 months notice before the increase is actualized as well. So that's 90 days notice. According to the calculation of days, which landlords are very familiar with, tenants may reduce rent increases that are greater than the percentage rate of inflation. So let's say, going back to that example from before, the rent was $1,000 in 2021. You can increase the rent by 8.1%, and that makes it $1,080. However, the landlord in this case raises it to $1,280. That's $200 more than what you're allowed to increase the rent by, and so you can deduct down to $200. But again, if you are making a rent deduction, you must do 2 things. 1, you must notify your landlord why you're doing it and the reason, and you must sign that letter. And 2, I would heavily advise you, especially if you don't have legal training, to call the Residential Tenancy Branch and make sure that this is a circumstance where you can withhold rent. And that does it for rental increases. I hope that helped, like I said. And wherever the landlord is, I hope you're doing well. You can do this. Shawn Adams, resolve it. So I'm going to do this video, this individual video, in 2 parts. How to end the rental agreement. There's a tenant side to things, and there's a landlord side to things. So, for tenants, a couple of different ways that you could end the rental agreement. If your agreement is fixed, you can already end the rental agreement whenever that end date is. And whatever the end date is, you need to move out by 1 p.m. on the date of the fixed rental. However, you want to move out sooner than whatever that date is. Okay, let's do that. So you can provide 30 days notice that you will move out. Doesn't matter whether the landlord accepts this or not. You can just make that announcement, start moving your things. You can move out with 14 days notice if you have experienced family violence. You can also move out with 14 days notice if you need to care long-term for a family member who's sick with a severe and pervasive disorder or illness or condition. Okay, so that notice you can provide. There is a form under the Residential Tenancy Branch website. If you go to the section under forms, there's a section there where you can provide your notice, however long it happens to be. If you don't have one of those other reasons for leaving, it would be 30 days notice. For landlords, so let's talk about this. The end of the tenancy for landlords. So there are a couple of different ways you can handle this. A landlord might need to evict a tenant. This is a good reason, better than the other ones. Personal possession, conversion, demolition of property. That's one reason that you can evict a tenant. So if the landlord is an individual, part of a family, or a family corporation, they can take possession of the property for themselves and their family, and they need to give a significant amount of notice about that. The landlord can take the property from the tenant and for themselves if they've sold the unit to another person, and that person decides they don't want to be a landlord anymore and they want to use the property individually. This usually happens if you're selling a condo or like an apartment that you purchase and you've sold the apartment and that person is not landlording anymore. The landlord can take the property for themselves if they're converting the rental property into a space for like a caregiver or a manager or a supervisor. So they may hire another supervisor on a multi-unit complex, and they may need a space for that supervisor to occupy. And in that case, it would be fine to evict the tenant with sufficient notice. It may also be a very large property. Maybe it's like a ranch, a working ranch, and they've hired a manager or a caretaker to take care of the ranch. They would be allowed to, if there's an extension to the property that they're renting, to turn that into an area for the caretaker. Let's see, what else? You can, landlords can demolish a property, they can turn it into a strata company, they can rezone it into a commercial space, they can convert the property into non-residential use, and they can do all of these things if they give sufficient notice. And the sufficient notice, I believe, is 90 days, a significant amount of time. In Ontario, it's 120 days. So tenants can dispute the rezoning or the demolition of a property within 30 days of the notice. And multiple tenants obviously would dispute that, and that could be a hearing that's heard with all of those tenants. The tenants may dispute landlords retaking personal possession within 15 days and say, no, I'm keeping this unit. And if the tenant wins with an RTB hearing, they will be allowed to continue to live there. The landlord may I can't talk today. The landlord may be required to reimburse the rent of tenants who are being evicted for any of the reasons that I've just given. And they'll need to follow some special notice guidelines that are in the Residential Tenancy Act and that are also in the regulations to the Residential Tenancy Act. So if you're a landlord, don't skip a beat. Make sure that you plan this really well, that you have enough notice given to your tenants, and that they know that they have to find a new place to live. Right of first refusal. So tenants have a right of first refusal if the rental units are repaired between the signing of the rental agreement and the move-in date. Usually what happens is the landlord changes the price of the unit to something that the tenant can't afford, and then they say, nope, can't do it anymore. And in that case, unfortunately, landlord has to find a new tenant. Landlords can end the tenancy for non-payment of rent. Pretty standard form. You can find that on the form for eviction. They can terminate with cause. Again, this is also on the form for eviction. So with cause means any of the following things. This is what you don't do when you're a tenant. Illegal activity by the tenant or their guests, an unreasonable number of occupants, significantly interfered with or unreasonably disturbed another tenant or the landlord, seriously jeopardized health, safety, or the lawful right or interest of another tenant or the landlord, put the landlord's property at significant risk, extraordinary damage to a rental unit, tenant does not repair damage in a reasonable amount of time, tenant breaches a material term of the lease after written notice of the breach, tenant assigns or sublets property without permission, tenant does not comply with an order of the Residential Tenancy Branch. If any of these things happen, chances are very good that you're going to be evicted. So don't do any of these things. The tenant can dispute an eviction notice by initiating dispute resolution through the Residential Tenancy Branch, or RTB. So a tenant can dispute an eviction notice within 10 days of being served if it is for cause, I believe, or also for non-payment. A tenant may dispute this eviction notice. If the tenant does not dispute the eviction notice within 10 days, they must vacate the property. So then the tenant leaves, right? What does the landlord do with personal property that's been left behind in a hurry? Because this happens a lot, in a hurry. The landlord can take control of the tenant's property only if it's been left for a month or more in a vacated or abandoned unit and the tenant's made no efforts to recover this property, right? So it needs to be deemed abandoned or lost or whatever, you know? The landlord may hold the property for up to 60 days, and during that time, the tenant or anyone who has an interest in the property can claim the property. And there might be a lot of value with the property. It might be something like they've left behind a vehicle or like a dirt bike or something that's worth a lot of money that perhaps their friend or family member might want to take control of. So if that's worth a lot of money, the landlord must give notice to anyone who might have an interest in that piece of property. They need to advertise the sale of the property actually in the newspaper using Section 72 of the Personal Property Security Act. So there's a special form, like a notice, that they need to put into the newspaper when they're selling this property. Now, if there is less than $500 of value in the personal property estimated, Or if the property is mostly damaged or garbage, it's things that, hoarder type stuff that nobody would really want, and you don't think that also that it has any personal value, that there's no personal meaning attached to any of those items, you can just dispose of that property, and you can notify the tenant that the items have been disposed. You can also decide to store those items, and if you store those items, the tenant has to pay for it. This is something for tenants. I think this will help tenants a lot, because these are 5 things that a landlord absolutely cannot do. And if they do any of these 5 things, the landlord can face a fine of up to $5,000 from the RTB. And that's for each offense. If they've done all 5 of these things, that's $5,000, $10,000, $15,000, $20,000, $25,000. So let's look at this. 5 things landlords absolutely cannot do according to the Residential Tenancy Act and the Residential Tenancy Regulations. Landlords cannot charge a guest fee. If they are charging for guests, then the RTB can charge them. The landlords cannot charge you beyond your first set of keys or key fobs. They can only charge you if you take 2 key fobs or 2 sets of keys. If your key or key fob is your only means of getting into the unit, if it's the only way that you can get in, they cannot charge you for it. And if they charge you for your key or your key fob, you can charge them through the RTB for a crime, a misdemeanor in the States, a summary conviction in Canada, of up to $5,000. The landlord cannot break the RTA and must comply with it. They cannot break the Residential Tenancy Act. They must follow what it says. For example, about contracting out of standard terms. You cannot suddenly decide that you are going to rent property to someone without any running water or electricity. You can't do that. You just can't. Otherwise, $5,000 fine. The landlord can't be sloppy with the tenancy agreement. What this means is the tenancy agreement needs to be in writing. It needs to be signed and dated by both parties, not just the landlord and the tenant, as well as any other landlords or tenants who are party to that agreement. They all need to sign it. It must be readable, legible, and it can't be any lower than 8-point font. So if you think you were going to do like a Willy Wonka thing and have a 3-point font where you can't even read it and you still have to sign it, that's super illegal, bro. $5,000 fine for you. It needs to be understandable, the tenancy agreement, and a copy must be provided to the tenant. Not an e-copy or a website where they log in and get their tenancy agreement. It must be a physical copy. That's it. That's acceptable. So no sloppiness with the tenancy agreement. If they are, $5,000 fine. The landlord must meet their obligations with respect to things like the locks being in good working order, the unit being in a general state of repair, providing adequate paperwork. They need to provide that tenancy agreement to you, physical copy. They need to provide an inspection report to you, physical copy. They need to provide a copy of the eviction notice, personally, with a physical copy, or by mail or courier if you're not at home. But they need to give you a physical copy of this essential paperwork. Reason being, if you're a tenant and you need to go to the RTB and do a trial or a hearing or a settlement conference, you're going to want physical copies of all of these things. E-copies don't do you any good if your computer craps out, or if it's on some cloud that you forget the password of, or if it's in your email and Google decides you can't use your email anymore. That does not do you any good. So make sure that you have a physical copy of all of your paperwork. If you're a tenant, if you're a landlord, you better provide all of that physical paperwork as well. Otherwise, you could face a fine. So those are 5 things that landlords absolutely cannot do. And if you have any questions about what your landlord is doing or what your tenant is doing, call Resolve It today. You can email us resolveitcanada@protonmail.com. We answer questions on a routine basis on YouTube for free. And we can also provide you specialized legal services. We specialize in tribunals like the RTB. So give us a call, give us a contact, resolveitcanada@protonmail.com. And don't miss our free legal clinics every Saturday. We'll see you then. And I think that concludes the legal clinic. I think that concludes it. Yeah. We're going to have a little break. We'll get to some questions. Until next time, this is Shawn Adams. You can do this.